Medical malpractice is a failure for a physician to use the acceptable standards of care. What is expected of that physician, that type of physician in that situation? And based upon the standard in his community, whether or not he meets that is the measuring rod, so to speak, of whether or not he's committed malpractice. Problem with the malpractice action is that there's many times medical negligence that doesn't necessarily lead to a severe enough injury for us to prosecute, so to speak, because in Florida especially, it's so difficult to initiate a case. We've got to have the records comprehensively reviewed, have a affidavit signed by a physician, usually a physician of like subspecialty or specialty, reviewing that, that series of records, and based upon his review and education, then sign this affidavit stating that there's medical negligence leading to an injury causing damages. So there's a lot of steps involved.
Is that something that a client should make the determination that the injury's significant enough?
Absolutely not. Whether or not there's going to be liability is a big branch of it, but we've got to know what your damages are as far as an injury. The only way we can know that is really what your future needs are going to be. If there's injury that has to have surgery in the future, if that surgery doesn't lead to the complete treatment that you're looking for. So it's not something that a client or an injured person in particular should or would be able to determine fully on their own.
Is it better to get an attorney right away or wait? What type of time constraints it might be able to?
Good question. Yeah, because of the statute of limitations with medical malpractice in particular, it's that much more sensitive. You've got 2 years from the date of injury or when you knew or should have known of a potential malpractice action. So time is of the essence, and when something like that happens, it's not necessarily your focus. You want to deal with yourself or your family member's injury, and so the time may be ticking. So it's something to be necessarily aware of and sensitive. You've got to contact us. We can do all the, as you know, if we get the right documents signed as far as a HIPAA form and the authority to represent and investigate the case, we can do all those things for them.
Can I represent myself in type of claim?
It is highly unlikely that you'd be able to follow the steps necessary. It's very complex, and in fact, you need to have the resources in place to even initiate a case. You can't just go down to the courthouse and file a lawsuit. You've got to put the doctor on notice of your intention to do so. And in order to file that notice, you need the affidavit, as we discussed. It's many times thousands of dollars just to initiate a case.
So time is really of the essence in a medical malpractice case.
Without question, and nothing's going to get better as far as in waiting. Let's just see what happens. No, you should put your ducks in a row, so to speak. Get everything in order, and we will do that for you, as you know. Get the documents signed, and we can get those records reviewed and give you peace of mind one way or another. Is there negligence associated with it?